Hello everyone, welcome back to the Indian Polity video lecture series for the Civil Services examination. My name is Shankar Rai, I'm your mentor. We are today in the video lecture number series number 4. To those who have not seen the previous 3 videos, I would recommend and encourage you people to kindly see those videos to have a clarity as well as the link on the consequent classes which we are going to have. Now let us go to the topic. In the video lecture number 4, that is this video, we are going to discuss on the Indian Constitution's amendments. That means the different types of amendments which our Constitution of India has gone through, and also the related issues or controversies which from time to time we have observed regarding the amendability of our Constitution. Okay, let's go to that. First of all, before we start the topic, I would also like to highlight that what is exactly is the meaning of the amendment. See, amendment means within code a change where in either way, if you want to omit some of the provisions of the Constitution, or if you want to add some provisions of the Constitution, or if you want to alter certain provisions of the Constitution, that is called as amendment. As we know that our Constitution is the supreme law of the land. So our Constitution has also laid down certain procedure. How do you want to amend the Constitution, or how our Parliament can amend the Constitution? So the Article 368 particularly that deals with the amendability of the Constitution, which sounds power of the Parliament to amend the Constitution and the procedure thereof, which means only the Parliament, I repeat, only the Parliament has the power to amend the Constitution, and the power is not available with the state legislatures. So I'll just quickly read a couple of provisions of the Article 368. See Article 368 clause number 1, it says, anything in this Constitution, Parliament may exercise of its constituent power to amend by way of addition, variation or repeal any provision of this Constitution in accordance to the procedure laid down in this article. The clause number 2 says an amendment of this Constitution may be initiated only by introduction of a bill for the purpose in either of the House of the Parliament when a bill is passed in each of the House by a majority of total membership of that House present and voting. It shall be presented to the President of India, who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the terms of the bill. So it's very simple that number one question arises, the Constitution, before you amend the Constitution, all of you know that the procedure to make an act, first of all you have to present a bill, then the bill will be passed in the Parliament with certain majority, then once it is getting assent of the President, then it will be converted into act. Now here what happens in the Constitution bill, the Constitution bill can be presented either in the Lok Sabha or in the Rajya Sabha. Okay, then there is a specific majority by which I'll be discussing in the consequent classes, specific majority by which the bill needs to be passed. So once it is passed, then the President must give assent to the bill and consequently it will become act. However, there are certain types of bills, which means if there is a bill which is related to certain articles of the Constitution, then prior permission of the President of India is required before presenting the bill in the either of the house, the Lok Sabha or Rajya Sabha. So the, for example, article 54, 55, 73, 162, 241, like chapter 4, chapter 5, that is union, the states, chapter 1 of the part number 11, any of the list in the seventh schedule, the representation of the state in the parliament. The provisions of this article amendments are also required to be ratified by the legislature of not less than one half of the states, which says that these are the some of the rigid clauses of our constitution. So in order to amend those provisions, not only a bill needs to be passed in the parliament with the requisite majority, but also it has to adhere, the resolution has to be passed in the particular state. Minimum 50% of the state, they have to agree with the particular bill. Once the bill is getting approved by minimum 50% of the states including the parliament, then only it can become an act by amending to the constitution. Article 368 clause number 3 says nothing in article 13 shall apply to the any amendment under this article. Now here is an important point I would like to highlight. See, article 13 which deals with the law. Now article 13 is a part of fundamental rights, that is a part 3 of Indian Constitution. Now article 13 says that nothing in article 368 shall be applicable, and here in article 368 clause number 3 it says nothing in article 13 shall apply to any amendment made under this article, which means whatever available to article 13 is not applicable to article 368. Now what is available to article 368? That is Constitutional Amendment Act, which means the article 13 which states or the define the law are not exactly the Constitutional Amendment Acts. Then what we tell the Constitutional Amendment Acts if they are not law? Try to understand. By definition of article 13, Constitutional Amendment Acts are not a law. They should be simply called as Constitutional Amendment Acts. However, if you try to understand a generic meaning of the law, when we talk about the different types of law, then yes, the Constitutional Amendment Acts is also a type of law, but it shall not be called as law as per the article 13 of our Indian Constitution. I hope this is clear to all of you. Let us come to the point. Now, as I have highlighted that there are certain types of majority by which you can amend the Constitution. First of all, before we try to understand the types of majority, you need to understand that our Constitution is a blend of both rigidity and flexibility, which means certain part of the Constitution you have to amend. You can amend with much more rigid provisions like I have just highlighted in the previous slide, and certain parts of our Constitution you can amend with a very flexible portions. You can amend with less type of majority, requiring majority. Now here there are three types of division which I have made. Amendment by simple majority. Simple majority means simply 50% of the present and voting. Okay, so it's simply like a minimum 50% plus 1. So if for example there are 100 number of is the total strength, then 50 percentage is 50 numbers plus 1. If that for that particular bill there are 51 number of votes agreed and saying yes, then the bill stands passed. Now what are the particular amendment bills or the provisions by which a constitution can be amended? Now here article 5 to 11, that is citizenship, article 169, abolition or creation of legislative council in the states, article 239A, creation of local legislature or council of ministers or both certain for the certain union territories. Now these articles specifically are excluded from the purview of the article 368, which means in order to amend, these are also part of the constitution, but if you wish to amend this part, then you shall not require to invoke the article 368. These articles or the provisions of the constitution can be amended by simply placing a simple majority. Now let us go next. Amendability with a special majority. Try to understand, anything which is not simple is special. Okay, so also there is a I received a couple of questions that in our constitution normally or generally we see that there are certain places where the constitution is silent by which type of majority the provision can be amended. Please note that if the constitution is silent, you need to understand that it can be amended by the simple majority. If the constitution has highlighted then definitely the majority, whether it is special majority and which type of special majority, that will be duly prescribed in the constitution. But the point to note that if the constitution is silent by what type of majority the constitution or the provisions can be amended, that it has to be understood that it is by the simple majority. Now what is the special majority? Special majority, which is not simple, as I have highlighted, articles which can be amended by special majority are laid down in article 368. All amendments except those referred to the simple majority come within the category must be affected by a majority of total membership, each house of the parliament, as well as not less than two-thirds of members of present and voting. Now only difference is in the simple majority I have highlighted 50% plus 1, but here the majority of the total membership, or else we can also say that not less than two-thirds members of the present and voting. For example, there are 90 and 90 is the total strength, so not less than two-thirds means minimum 60 members plus 1 has to be present and voted for the favor of the particular bill to be passed as a special majority. So that is the detail of the amendability by the special majority. Now going next, amendability by the special majority as well as ratification by the states. So this is one of the more rigid functions we have already understood in the previous also while we're discussing with the article 368. I have already highlighted that, like for example, provisions, election of the president, manner of the election of the president, executive power of the union, executive power of the state, the union judiciary, high courts of the states, high courts in the states, high courts for the union territories, distribution of the legislative powers, and the article 368 itself. All these provisions are very rigid in nature. So in order to amend those provisions, we need a special majority to be passed in the parliament, which means not less than two-thirds members of president voting to be passed in the parliament, as well as plus the ratification by the states. However, the ratification of the states needs to be by the simple majority. Please try to understand this special majority is only for the parliament, and the ratification has to be by the simple majority, that is 50% plus 1, but minimum 50% of the all the states, they have to pass this particular act in order to pass or in order to convert into law and by amending the constitution. Now going by, let us try to understand certain the controversies of the story regarding the amendability, because only the factual informations are not important for the examination per se. They'll be more interested into how much in-depth knowledge you are having. So number one controversy is that whether fundamental rights are amendable. Can we amend the fundamental rights? As we know that fundamental rights are fundamental and very integral part of our constitution. That is a part 3 of our Indian constitution. So can we amend it? And number two, that scope and authority of parliament to amend the constitution. As article 368 clarifies, it has the power to amend, but what is the limitation of the power? Can parliament amend any part of the constitution, or is there any limitation put on the parliament that up to what certain limit or what kind of provisions by which a parliament can amend or parliament cannot amend? So let us go through these particular controversies, and I hope that by going through you'll be able to understand the entire scenario of the Indian polity, especially related to the amendability of our constitution. Now, the story of the amendability of the Indian constitution, I have highlighted and given you people with limited information. I do not want to give you the burden of so many facts and the information unless and until you are a student of the political science optional. So if you try to understand and remember the 8 number of points which I have just mentioned, the story will be sufficient for you to understand the two controversies. One is whether the fundamental rights are amendable or not, and second part, what is the power of the parliament, or to what extent the parliament can amend the constitution. Now I will always recommend you people to do not alter those sequence. So please follow this sequence. I have made this sequence for you people, so it's better that you should revise again and again. So let us understand by a story and not by understanding merely as facts. First of all, now the story starts with our first constitutional amendment act of 1951. That means for the first time when our constitution was being made attempt to amend certain provisions of the Constitution. And with the first Constitutional Amendment Act, some of the provisions of our Part 3, that is the fundamental rights, were amended. Now, this particular first Constitutional Amendment Act was challenged in the Supreme Court of India in a very famous case of Sankari Prasad versus Union of India, 1951. Now, let us understand what the judiciary has said. Let us understand what Supreme Court of India has said. The Supreme Court of India has told that the Parliament has two types of power. Okay, the Parliament has two types of power. Number one, it has constituent legislative power, and number two, it has ordinary legislative power. Now, the Supreme Court further clarified that with the use of the constituent legislative power, the Parliament can amend any part of the Constitution. Second, however, with the use of ordinary legislative power, the Parliament does not have the power to amend the Constitution. Okay, so in that way, we can simply say, yes, Parliament has the power to amend the Constitution, including the fundamental rights. Now, the Supreme Court continued the particular statement up to Sajjan Singh versus State of Rajasthan 1965 case. So till 1965, the Supreme Court has been taken the stance that yes, Parliament has the power to amend the Constitution, including the fundamental rights. Now, in a very famous case of Goloknath, for the first time, the Goloknath versus State of Punjab 1967, when the case arose again regarding the amendability of the fundamental rights, the Supreme Court held that no, Parliament cannot amend the fundamental rights. What is the reason? The reason stated that Article 368 only has the procedure. Earlier, in that particular 1967, the Article 368, which lays down the procedure of the amendability of the Constitution, has mentioned only the procedure, but it doesn't mention the power of the Parliament to amend the Constitution. Okay, so in that way, the Goloknath case has clearly stated no, Parliament cannot amend the fundamental rights. With that, all of you know that in order to overcome from the any kind of judgment, the Parliament has to pass a law. The Parliament passed the 24th Constitutional Amendment Act of 1971. Now, with that at 1971, it has modified the Article 368 heading. Number one, the previous heading was the procedure for amendment of the Constitution. Now the heading has been modified as the power of the Parliament to amend the Constitution. So as well as it also introduced Article 368 clause number 3 and stated that nothing in this particular article shall be applicable to Article 13, which means by this 24th Constitutional Amendment Act, Article 13, the definition of law and the constituent amendments are being segregated. Okay. Now, by doing this, in the 24th Constitutional Amendment Act, further what happened? There was another case. It was challenged in the Kesavananda Bharati versus State of Kerala 1973. Very famous case. In this particular Kesavananda Bharati case, to be very specific, the judgment was announced on 24th April 1973. Now, this case was challenged as it held that the Parliament can amend any part of the Constitution, including the fundamental rights, but not the basic structure. Basically, the basic structure in the previous video, please go and watch. I have already explained what is the basic structure and what are the provisions of the basic structure. So basic structure is a judicial innovation which has been innovated in the Kesavananda Bharati case, and it stated clearly that in the basic structure, except the basic structure, the Parliament can amend any part of the Constitution, including fundamental rights. Now further what happened, the 42nd Constitutional Amendment Act 1976, it made certain changes in Article 368. You people please note this particular year because 1975 was the emergency. So 42nd Constitutional Amendment Act is also known as mini constitution, because almost more than half of the constitution has been amended by this particular act. Now it inserted article 368 clause number 4 and clause number 5. Now clause number 4 says that the constitutional amendment shall not be called in a court of law, which means clause number 3, article 368 clause number 4 clearly taken away the power of the court to intervene or review the constitutional amendment acts. And at the same time, article 368 clause number 5, it stated that there shall be no limit whatsoever to the amending power of the parliament. Now further, this particular 42nd Constitutional Amendment Act further challenged in the Minerva Mills versus Union of India 1980, and the Supreme Court further clarified. It first struck down the both the articles, article 368 clause number 3 and clause number 4 and clause number 5, and it said that it takes away the basic structure of the constitution. The basic structure means the judicial review is a type of basic structure, so this is not constitutional valid. And also in the Minerva Mill versus Union of India case, the Supreme Court further stated that limitation of amendability power of the parliament is also part of the basic structure. Okay, so this is the story of the amendability of the constitution. Now what is the current stance? Current stance is what has been stated in this particular I would say case 1 on the Bharati case, that the parliament can amend any part of the constitution except the basic structure. Please note that there is no list of the basic structure, neither the Supreme Court has also given the basic structure. It's simply from the time to time whenever it comes, so they have given that particular list, or we are getting from the various kind of judgments, or maybe in kind of other laws or other kind of judgments. So this is the story of the amendability of the constitution, which I have tried to explain to people. Now with that, I'll just give a brief about the different types of amendment. These are merely a factual basis. I will recommend you people to pause down the videos each time and please note it down each and every word. So I have not mentioned the what type of articles are being amended or the provisions, because from those areas questions are not being asked, and it's also very difficult to remember all the articles, but just go through that. Like 70th amendment 1956, the reorganization of the state. Earlier we used to have a like class A, B, C, D states, introduction of the union territories. Then a 9th amendment, it adjustment of the Indian territory as a result of the agreement with the Pakistan. 10th amendment 1961, Dadra Nagar Haveli incorporation as a union territory. 12th amendment, Goa Daman Diu. Then 13th amendment, Nagaland was formed with a special status under article 371 of our constitution. Further, 14th amendment, Pondicherry incorporation into Indian Union. Then 42nd amendment, like for example fundamental duties prescribe India becomes socialist, secular and republic. Earlier those words were not available in the preamble as well. The 44th Constitutional Amendment Act, right to property removed from the list of the fundamental rights. Like 71st amendment, Manipur, Konkani, Nepali were added in the 8th schedule of our Indian constitution. So is the case for the 73rd Constitutional Amendment Act. The Panchayati Raj added in the part 9 of the constitution has been added here. 74th is related to the municipalities. Recently the Panchayati Raj Day was being celebrated, so these two amendments are much more important. So I'll be discussing these two amendments separately as a class. And now 86th amendment, free and compulsory education to the children between 6 to 14 years, that is related to article 21A of our Indian Constitution of Fundamental Rights. 87th Constitutional Amendment Act, Santhali, Bodo, Dogri, Maithili in the 8th schedule. Then we are having 96th amendment, replace Odia for Odia. The change of the words has been put into place. 97th Amendment Act, it was related to the introduction of part 9B in the Constitution of India relating to cooperative societies. So is there also certain amendment like 100th amendment regarding the India-Bangladesh exchange of the conclaves. 101st amendment, that is related to the GST. 102nd amendment, that is related to the constitutional status of National Commission for Backward Classes. Then we are having 103 third amendment, that is maximum 10% of the reservation for economically weaker section. Earlier there was no reservation on the basis of economic, but for the first time there was a constitutional amendment regarding the economical section of the reservation. So these are the couple of articles which I have explained for you. I hope you have enjoyed the video, and if you are having any kind of query or any kind of doubt, please let me know. I'll be happy to solve all of your doubts. And with that, thank you for watching, and I'm looking forward to see you again. Thank you.